If you want to live and work in the United States and are finding it difficult to make this happen legally, the prospect of marrying a U.S. citizen or green card holder may seem like a possible solution. However, if your marriage isn't based on a real desire to build a life with your spouse, this approach is very risky. Here's everything you need to know about getting a green card through marriage. A marriage green card gives the spouses of U.S. citizens or green card holders the status of legal resident and the opportunity to live and work anywhere in the United States. There are two types of marriage green cards: a permanent residency green card and a conditional residency green card. A permanent residency green card is for couples who've been married for more than 2 years at the time of approval of their case. In these cases, the spouse applying to receive a green card is eligible to receive a green card lasting 10 years, after which it needs to be renewed. Spouses who've been married for less than 2 years at time of approval are granted a CR-1 conditional marriage green card. This grants you the same ability to live and work anywhere in the U.S., but conditional marriage green cards cannot be renewed. Instead, you must petition to remove the conditions within the 90-day period before your conditional green card expires. You'll also need to again prove that your marriage is real. During this time, USCIS would expect you to have new pictures together, new joint financial documentation, and possibly even children. Whatever type of proof of your relationship you included in your original application should also be used the second time around, presented in accumulation. Eligibility requirements for a marriage green card include being legally married, having a bona fide relationship, and having proof of the petitioning spouse's U.S. citizenship or lawful permanent resident status. Beyond these fundamental requirements, there are other restrictions to keep in mind. Bars to adjustment are rules that exclude certain applications for permanent or conditional residence based on acts or violations that have been committed, even if the individual didn't realize they existed in the first place. Many foreign nationals are eligible to apply for green card status, but sometimes an individual is denied if one or more bars to adjustment of status apply to their situation. The three most common statutory bars to adjustments are unlawful status. This bar applies if the applicant for the green card is an unlawful immigrant at the time of filing. This can occur when a person's immigration benefit, such as visa, parole, or acceptance to a visa waiver program, is revoked or has expired. Staying in the country beyond the duration of the benefit results in unlawful presence. Failure to maintain status. This bar applies if the applicant for the green card has failed to maintain a lawful presence in the U.S., which includes the current trip and any previous. This usually occurs if an individual overstays their visa. There's a difference between the expiration date on your visa and the amount of time you may be permitted to stay in the country. Your visa may be issued for a certain period of time, but this does not always match your Form 194 arrival departure record, which dictates the length of your authorized stay in country. If you leave the country after the last date written in this record, you will have overstayed your visa, unauthorized employment. This bar applies if the applicant for the green card performs any service or labor within the U.S., but isn't permitted by USCIS to accept any employment. This bar also includes employment that exceeds either the scope or duration of authorizations that the applicant has received. Similarly, as with bars to adjustment, there are certain grounds that make applicants inadmissible. If one or more grounds apply, the applicant won't receive permission to enter or remain in the United States and cannot complete their application for permanent residency. Some of the most common grounds for inadmissibility are health-related grounds, criminal-related grounds, security-related grounds, public charge, unlawful entry and immigration violations, documentation requirements, aliens previously removed. All individuals applying for adjustment of status are treated by immigration law as though they're outside the U.S. and seeking entry, regardless of whether they already have a physical presence here. So grounds of inadmissibility apply to foreign nationals who are both outside and already inside the United States. Several U.S. immigration authorities have the power to determine whether or not an individual is inadmissible, including the U.S. Department of State, Customs and Border Protection, and USCIS. The marriage green card process involves three main steps: filing Form 1-130, Petition for Alien Relative, submitting the green card application through either adjustment of status with Form 1-1485 or consular processing, and attending a green card interview. The cost of a green card through marriage varies depending on whether the applicant is inside the U.S. or applying from abroad. The processing time for a green card through marriage can range from 8 months to 3 years, with different timelines based on the type of processing chosen. If you're planning to go through the green card marriage process, you should also understand the implications of a divorce when a green card marriage is the foundation of your United States residency. For a full 10-year green card, divorce typically won't affect the renewal process. However, for a 2-year conditional green card, divorce requires applying to remove conditions to obtain a permanent resident green card. If divorce occurs during the application process for a permanent resident green card, the process stops. Although it's not strictly necessary to hire an immigration lawyer for your green card application process, having professional support can be extremely valuable. They can help you navigate and complete the many complex applications and processes. It's highly recommended to hire an immigration lawyer if you face any of the following circumstances. You're in deportation proceedings. You entered the U.S. unlawfully at any point you've committed a crime. You previously lied to the U.S. government to get immigration benefits. Even if none of these situations apply to you, working with an immigration lawyer offers a lot of benefits. They'll investigate and confirm your eligibility for a green card, prepare your forms and supporting documents, and keep you on top of any critical deadlines, among other functions. Consider these benefits in your options to ensure you have the best conditions for green card success.